So, good afternoon, everybody. Quick introduction from me. My name is Gemma Young. I work for Setford Solicitors. Anybody looking up Setford Solicitors will see our offices are based in Guildford and London, but I tend to work from home. I'm based in Bedfordshire, so hopefully I'm not too far away from all of you. As Claire says, I'm going to be talking today about understanding probate, what you need to do, what you need to consider, etc. I will pause at my fourth slide. I've got 8 slides in total. My fourth slide for any questions, and then we will pick up the talk thereafter. So, what is probate? What do you need to do? What does it all mean? First of all I want to say is a lot of people get mixed up with probate and lasting power of attorney. I think because there's a P in both those, power of attorney and probate. There's a lot of confusion about what is needed for when. So I'm not going to talk about anything to do with lasting powers of attorney today. That's a separate talk, separate slides. Probate is what happens when we pass away. It's a process we need to go through. We may need to report to HMRC that somebody has passed away, what their assets are, what their gross, what their net estate is worth, whether any tax is to be paid. I'll come on to some more slides with that in a moment. Once you've dealt with HMRC, if indeed you need to, then it is the process for applying for probate, grant of probate or grant of letters of administration if somebody has died without a will. So what do we need to do when somebody passes away? So first step is to register the death. You will not be able to register a death until a doctor or a coroner has signed off the cause of death. I have dealt with a fair few probates in my time where there may be suspicious circumstances or unexplained circumstances as to why somebody has died until such time that a doctor or somebody else, a medical professional, a coroner has signed off the cause of death. Only then can that cause of death be put onto a death certificate. So you won't be able to obtain the death certificate. You won't be able to register the death until that medical signing off has taken place. But once that has happened, you will need to formally register the death. Now, if you've got wills where you have nominated firms of solicitors as your executors, that's perfectly fine. Generally, the registrars will want a family member registering the death because there's going to be lots of personal family questions that the registrar is going to ask the family about the person that's died. The solicitors aren't necessarily going to know that information, the family history on health, medical, who was mum and dad, that sort of thing. Family members are going to tend to know those answers better than solicitors. So do think if you've got a will, have you nominated solicitors as executors, but they are not going to be the people who, they can register the death. Don't get me wrong. If there is no one else, again, I've dealt with a fair few probates in my time. Sometimes I deal with deaths, there are no family members. So it does have to be the solicitor. But answering those questions, getting that full fact find about the person that's died, it's better off for the family to do that. As part of registering the death, you'll be provided with a code by the registrar called a Tell Us Once code. Again, better for the family if applicable, if relevant, to fill in this Tell Us Once code. It is going to tell the Passport Office, DVLA, Blue Badge, HMRC if you are an income taxpayer, DWP if you're in receipt of a state pension, all those agencies. It will tell them all in one swoop, once you've got the code, that Joe Bloggs has died. Okay, so you don't need to be contacting these organisations separately. It will tell everybody in one swoop under that code. Obviously, if there is a will, if the deceased did leave a will, you do need to locate the original. Again, I deal with probate on a daily basis. Sometimes I'm being asked to deal with probates on behalf of the family, who might be down as executors, and I'm being sent photocopies of the will. What the probate registry want is the original. So do have a look and see, do I have the original will? Is it definitely the original will? Have a look at the signature page. Is it that wet ink signature, which is what the probate registry will want to see? If a original will has been lost, you will be expected, as your role as executor by the court, to do all reasonable searches to find that will. So it might be a case of writing to all the local firms of solicitors where the deceased died. Did they do a will locally? Is that firm of solicitors storing the original will? The court will expect you to do all reasonable searches to locate the original will. If the original will cannot be located, after all reasonable searches have been done, and you have a photocopy of a signed photocopy, the court may accept that. But I think the moral of the story is don't hide these documents too well, because they will be needed, and the court do want to see the wet ink original if possible. Okay. Lasting powers of attorneys, if the deceased had those during their lifetime, they immediately come to an end when they've died. This can cause some problems in the past where Joe Bloggs, I'll call the deceased, might have had a set of attorneys managing their affairs whilst they're alive. Joe Bloggs has then got a separate set of people acting as executors under the will. So it causes some confusion and some arguments as to when the attorney's role, when their duties, when their power comes to an end, and when the people in the will take over. Okay, so the power of attorney will immediately end on death. The attorneys have no more power to continue acting. Obviously, if it's the same attorneys under the power of attorney is in the will, that's absolutely fine, but you need to know what hat you're wearing. Am I an attorney? Am I the executor? All right. The first thing you must do, which I advise everybody to do, is if the deceased owned property in their name, first job is to notify the house insurance company. The insurance will immediately cease the moment the proprietor of that property, whose name is on the insurance documents, has died. Also, it's worth noting that some insurance companies will not continue to insure a property where that property is now empty. So if you had Joe Bloggs living in that property on their own, that was the basis of the insurance being provided to them, that somebody was living in that property. If no one's living in that property while we're dealing with probate and selling the property and all those sorts of things, double check with the insurance company, will you still insure the property now that the property is empty? And it will be empty until such time that we go through probate, selling the property, etc. Okay. Excuse me. So once you've done the first set of formalities, what you need to do next in your role as executor or administrator, if there is no will, is calculate the estate. Now, this is going to take some time. You will probably need to be doing things such as writing to the banks, writing to premium bond shareholders, also obtaining the liabilities. So it's not just the gross value of the estate that the court wants to know about or HMRC wants to know about. It's also the net estate. So you can deduct the liabilities that the deceased had. So funeral costs, wake costs, there might be care home fees that need, last care home invoice that might need to be paid. Those sorts of things you can deduct off the gross value of the estate. If there is any inheritance tax to pay, you are only paying the inheritance tax on the net estate, not the gross. So you are deducting off the liabilities, off the gross, leaving the net, and then it's the net that is taxable. Okay, so this will take a bit of time. In my experience of writing to banks, some banks you can deal with digitally online. You can upload documents to the portal. Excuse me. Others still like a good old-fashioned letter and copy death certificate in the post. So that will take about 4 to 6 weeks for you to start notifying everybody. Don't forget, you can only really notify banks and other financial organisations once you have that death certificate. So if you are still waiting for doctors, coroners, etc., to sign off the death, you've got a long waiting period here before you can notify anybody. The bank certainly will not take your word for it that Joe Bloggs has died without a copy death certificate to prove that. Okay. Okay. Inheritance tax. Now, you are personally responsible as executors for reporting the gross and net values of the estate to HMRC. Now, again, you're not going to be able to do any reporting to HMRC or the probate registry until you've got those letters starting to come back to you once you've made your initial inquiry saying, "Dear Santander, Joe Bloggs has died. I'm the executor. Here's a copy death certificate. Can you let me know what your requirements are to close off the account? And can you let me know what the date of death balance in that account was?" Those are ultimately the things that you're asking the bank. So once you've started to get those letters in with those responses, those figures, it's the important thing here is the figures is what you want. That is then when you will start to report to HMRC. Excuse me. Sometimes even where there is no inheritance tax to pay, you might still be required to file a tax return. I'll just give you a bit of an example here. Everybody's got a basic inheritance tax relief of £325,000 per person. So I've got one, you have all got a basic nil rate band relief of £325,000. If you are married or in a civil partnership and you've got the correct wills in place that allows for those nil rate bands to be transferred between husband, wife, civil partners, then on second death, when the second one of you has died out of husband and wife, civil partners, you can transfer across the first death's nil rate band across the second. So if husband has died first, 5 years ago, wife then dies 5 years later, provided the husband prepared the correct will that allows for that transfer of his tax band over to wife, then you can do that. So you can add on husband's nil rate band of £325,000 to wife. What you will need to understand, though, is sometimes in probate, you might get a first spouse that died 10, 20, 30 years ago. The nil rate band then is not going to be what it is today. So you can only add across the first spouse's nil rate band at the time that they died. So you might need to look at the table, which you can get that offline, as to what the nil rate band was in that relevant year. All right. So be careful there. You're not necessarily adding 325 to your 325. It depends when the first spouse died. So you need to work out whether the estate is taxable, what the tax nil rate bands are, and whether you can add them together based on what the will says. In addition to the basic nil rate band of £325,000, there is also a residential nil rate band of £175,000 as of today's date. Again, if you go back a few years, starting point was £100,000, but today's date is £175,000. So in short, if you've got a married couple civil partnership and they've died in quick succession of each other within the last few years, they've both got a basic nil rate band of £325,000. And if they own property and are leaving their property down to their direct descendants, which is down the bloodline, so if we think children, grandchildren, and so on, then you can look to protect up to £1 million tax free. Now, even if your estate is non-taxable, you might still need to fill in the tax return, applying all of these reliefs. So you're building in husband's nil rate band, wife's nil rate band, the residential nil rate band. You got to build all of it up to show HMRC that the estate is under £1 million. You've got all these tax bands that you're adding into the return, and therefore making the estate non-taxable. Okay. So do consider whether you'd need to file a tax return before applying for probate. Certainly the probate registry will chuck back your application if they feel that you should have reported to HMRC and you haven't reported to HMRC. There is a questionnaire that the probate registry will ask you as part of your application. Have you filed a tax return with HMRC? Once the probate registry have received all the information about the deceased, including the gross and the net figures of the estate, if you have indicated that you haven't reported to HMRC, they will throw back your application for probate and say you must file a tax return with HMRC first before you come to us. Now, if you are having to report to HMRC whether the estate is taxable or not, once HMRC look at your application, your IHT 400 and all the other supporting documents that go with it, they will provide you with a code. So once they're satisfied with the tax, they will provide you with a code that says, I've looked at your tax return, I agree or disagree with your figures, or this is what I think you should be paying. You either need to make a first instalment or you need to pay all of the tax. We will then release this code, and you need this code in order to apply for probate. Okay, so you'll need to understand, do I need to do a tax return? Do I need this code? Or can I straight away apply for probate? The answer to that is all going to be dependent on the size of the estate. Okay, so what assets are in the estate and so on. Now, if there are insufficient, so say, for example, the only asset is a property, there's no liquid assets, as I call them. There's no bank account money, there's no premium bonds, there's no shares. All the asset is a house, there's nothing else, but the estate might be taxable. How are you going to pay the tax? You can apply to the bank for what we call a bridging loan. So you could go to the bank and say, Joe Bloggs has died, I'm the executor, there's a £35,000 tax bill to pay here, there are no other assets to pay the deceased's tax, he only owned a property, I obviously can't sell the property until I've dealt with HMRC, probate registry, etc. Can you loan to me, Mr. Bank Manager, a sum of money, £35,000 to pay HMRC? They then release to me the code, I can then apply for probate. Once I've got probate, I can then sell the property. I can then pay back the loan of £35,000 and discharge any other debts the deceased had and distribute the rest in accordance with the will. So applying for probate is very much a step-by-step process. You can't do one without the other. So if you have got assets that you're collecting in with the bank or a property needs to be sold, first of all, you will not be able to sell a property without probate in. Okay, so if you do have a property there, again, you can't apply for probate until you've dealt with HMRC. So you see the steps here. Number one is reporting to HMRC. 2, paying any tax applicable. 3, applying for probate once you've got that code from HMRC. 4, once you've got probate, you can then collect in the assets that require probate and sell a property. So I say that because lots of my clients get very eager when somebody has died to start marketing the property for sale. Well, you can do that. You can market a property for sale. You can get agents in. You can even show people around. You can accept offers. What you can't do is complete without probate. So if you have got an estate where you do have to do an IHT 400, a tax return, I'm not joking you when I tell you that it will take HMRC about 4 to 6 months to look at your application. So what you need to be careful is any prospective buyers who might want to be looking around this property, you need to be making it abundantly clear that the property is subject to probate. It could be subject to HMRC. HMRC are not fast people. They will take about 4 to 6 months to look at your tax return, decide whether there are any issues. If there are any issues, or if you haven't paid the tax, that 4 to 6 months clock is going to start again. That's the other thing. So if HMRC write to you and say, we've received your IHT 400, thank you. However, there's a few issues. We don't agree with this, we don't agree with that, you haven't paid the tax. You reply with the information that they've asked you for, but you've then started that 4 to 6 months clock again. My advice, if you've got a property to sell, do not even think about marketing the property until you've got over that HMRC hurdle, because you're just going to get disgruntled buyers, estate agents jumping up and down, not happy that, they thought we could be done by now and we're still in the hands of HMRC. So I wouldn't even advise bothering marketing a property until you've dealt with HMRC. Okay. Application for clearance. I will speak about this in the last slide because this is kind of a last step. But what we used to have to do with HMRC is, even if HMRC approved your tax return, they approve the figures, they approve the tax that you've sent into them. What we used to have to do was then, at the end of the estate, was prepare an application for clearance, which is basically another application going into HMRC, which again will take a few months for them to deal with, that says, I'm now at the end of the estate. You've looked at my tax return a few months ago. I've paid the relevant tax. You said that was fine. I'm now asking HMRC to clear off that they have got no further queries, that you're fully satisfied. There's nothing else for me to do. You're not expecting me to do anything else. You're not going to have another look at this tax return and think, actually, there might be another £10,000. Now's the time for HMRC to look at it, raise any last queries they might have, and let you know what they are. Now, HMRC then got a bit fed up with these applications for clearance being sent in, because some of them took the view, we've already told you what the tax is, you've already paid it, we don't have any other questions. Others, it's unfortunately, it's a case of whose desk it lands on as to what position they took. Others were very much, well, no, I'm going to have another look at this application, and there may well be a few more queries that I've got, which means don't distribute. What you don't want to be doing in your role as executors or administrators is distributing in an estate where HMRC haven't cleared off, they haven't signed off your tax return. The last thing you want to be in as executor is where you've distributed thinking HMRC have got no further questions for you. The beneficiaries have run off with all the money and spent it all. There's nothing left. And then a month later, you get a letter from HMRC saying, actually, we've had another look at your application. There's some more tax to pay. You are well within your rights as executors and administrators to hold on to that money, the estate money, until HMRC and anyone else, the probate registry, etc., have finalised their work. You are personally, as executors, responsible for handling and dealing with the estate. So you don't want to be distributing too early. Okay. Right. So we've dealt with HMRC. We've got our code. We've paid some tax. Now is the time that you can apply for the actual grant of probate itself. Now, is there a will? If there is a will, a valid will, a hard copy, a wet ink signature will, you're applying for grant of probate, a more straightforward route. If the deceased died without a will, or they might have made a will but it might never have been signed, or nobody can find it, after all reasonable searches, there's no evidence of a valid will here. If there is no will, then you are applying for a grant of letters of administration. So the two court orders do both jobs. It's just one died with a will, one died without a will. If you're having to apply for a grant of letters of administration, excuse me, depending on how you were related to the deceased, will depend on whether you can apply the quick way or the short way. So applying for probate, you can do online. You can go onto the probate registry and do that online. If the deceased died with no will, if you are a spouse of the deceased or a child of the deceased, you can also use that online portal. If you are what we call further removed, so parents, grandparents, aunts, uncles, nieces, nephews, you will not be able to use the online application. You will have to use the old-fashioned paper application to apply for the grant of letters of administration. That will take the probate registry another good 6 months to deal with. So you see the timelines here. There is no point in marketing a property for sale if you are a nephew of the deceased. He didn't have a will, the deceased, his estate is taxable, because first of all, you're going to be in HMRC's 6 months time scales. Then you'll get the code, then you can apply for the paper application for probate. You're waiting another 6 months. So sometimes people say to me, oh, I can't believe how long probate takes, because my next door neighbour who lost their mum, it only took about a month for probate to come in. Well, that probably meant that mum's estate wasn't taxable. She might not have had to do a tax return. And she might have had a will. All these things make it a lot easier, you see. She might have had a will, which meant that the daughter's down as the executor. It's easy peasy. However, if mum died with no children, with no spouse, with no will, estate is taxable, just left one niece, we're looking at the longer route here, okay? So unfortunately, if people don't prepare wills, whilst these things are all doable and we'll get there in the end, it's very much the long route that you're in here, the long game with HMRC and the probate registry. So, be careful of, don't compare yourself to others, because somebody else next door, their parents' estate might have been a lot simpler. They might have made their will a lot simpler, might not have been taxable, etc., etc. I'm just going to take another sip of water, sorry. If we have a deceased where there is no will, then you will need to work out what we call the intestacy rules, which is Joe Bloggs died without a will. Number one, who is entitled to make the application to the court? It isn't just anybody. There's a hierarchy order of family. So it's spouse, it's children, it's parents, it's siblings. There's a hierarchy as to who can apply. You'll then need to work out who are the beneficiaries, because without a will in place, again, under the intestacy rules, the law will tell you who the beneficiaries are. I've got a probate case on the go at the moment where it's my clients, it's their uncle that's died. So I'm applying for probate on behalf of one nephew and two nieces. Before we got to that stage, I was contacted by, he told me he was the brother of one of the brothers of the deceased. fine, you're the next person in line to apply for probate and to be the beneficiary. I mean, this brother nearly moved into the deceased's empty bungalow thinking he was the beneficiary. As I have undertaken a bit more of a fact find about who the family are, let's have a look at the family tree. It turned out this brother failed to tell me that he was in fact a half brother of the deceased, which means he wasn't entitled, one, to apply for probate or as a beneficiary, because there were other family members in the queue ahead of him, if you like, which in this case was nieces and nephews of his whole blood siblings who had died before him. I won't bore you all the details, but you just need to be careful. And I'm sure these two half brothers, you know, I'm sure they dropped the half many years ago and just refer to each other as brothers. But that's very important when we're looking at probate. Okay, unfortunately, the half then comes back in and you are removed from the situation. You're not a beneficiary and you are not entitled to apply. As you can imagine, family uproar, World War III, and had this uncle have been a bit more organised with his life and prepared a will, it would have made it a lot more easy and simpler, but he didn't, and this is where we are. So think about that. Who is entitled to apply? Who are the correct beneficiaries? Okay. Consider whether there's an IHT position, an inheritance tax position. And ultimately, when you are ready to make your application for probate, it is a legal statement application you are preparing to the court. If anyone's dealt with probate in previous years, you might be familiar with the affidavit that we used to have to prepare called oath for executors or administrators. If you are applying for probate via the online portal route, then all you need to do is prepare a legal statement. Okay. I believe, Claire, that is my fourth slide. So do you want me to pause for questions?
Yes, please. I will stop pausing.
Can you all see? Okay. So we've dealt with HMRC, we've dealt with applying for probate, we've now got the grant of probate in, or grant of letters of administration, whatever route you've gone down. Things to consider. Now, is anybody going to contest your will? If you've got a will that says mum, dad had 5 children, but it's only leaving everything to 2 of them, what's going to happen there? The court are seeing and inundated with applications contesting wills, even more so than we used to. People aren't happy these days, so everyone's in court fighting about it and falling out with family members. You will want to, when the grant of probate has been received, you will want to make a note of the date on the grant of probate, and you will not want to distribute to anybody, whether we're talking the house is sold, put it all in that executor's account. You've collected in all the bank money, put it all in that executor's account. You will not want to distribute to anybody for 6 months. And the reason for that is that if anybody is going to contest the wills, they've got 6 months from the date of the grant of probate. The moment you have got probate in, the will, if there is a will, and the grant of probate are a public record. So anybody can go onto the court website and have a look at anyone's wills where probate has been applied for and extracted. So be careful. Again, it's a bit like HMRC and not distributing too early. If HMRC then send you a letter a few months later, this is the same rule. You do not want to distribute to the beneficiaries and they've spent it, it's gone. And then you get a letter from the court saying, Joe Bloggs is going to contest mum and dad's will. You've got rid of all the money, you've distributed it. You are personally liable. That's going to come out of your pocket, not the beneficiaries. So do be careful there. A lot of people don't realise in their role as executors, the personal responsibility that's on you. So you're well within your rights to hold fire, delay distribution. You're entitled to do that until HMRC have signed off their accounts and that you have gone past that 6 months period and nobody has made any noises that are going to be contesting the will. All right. The beneficiaries won't care. They've spent it. It's nothing to do with them. You are the executor. You've distributed to them. Unfortunately, it's all on you. You are personally responsible. You could also be sued for not doing your job properly. So be careful of that. If you've read the will wrong, for example, you could be sued if you've distributed to one person. A bit like, go back to my half brother case. If I've not asked that question, he didn't drop the half bit on purpose. He just said my brother. It was only me digging. I've learned that he's not a whole blood brother, he's a half brother. There's a huge difference there. But if I'd have distributed to that brother, if that brother had moved into that bungalow and taken all the money, and I hadn't done my job properly, I could be personally sued for that. So luckily, right from the off, I've done my investigations. And you see that it makes a huge difference. Bear with me. Trustee Act notices. This is if there are any creditors out there that you are perhaps not aware of. Mum, dad might have had a loan, credit card, where there is a debt to be paid. So there is a difference here between a friend or family contesting the will, which is the point above, versus a creditor due their liability back to them. All right. So if I have a £5,000 credit card and I die, that £5,000, some people think that when you die, these debts are written off. They're not. Certainly not if there is sufficient assets in the estate to pay it. So if I own a house and I've got a couple of bank accounts, this £5,000 credit card isn't going to be written off. It needs to be repaid. This also comes back into the liabilities that somebody was asking earlier on. You can add all this into the liabilities. So if you are paying tax, you can say, well, there was a debt of £5,000 due to Santander. That will all come off the net value of the estate, bringing that tax bill down a bit. So you might see this in newspapers. It's at the back of the newspapers where people advertise that somebody has passed away. What they are doing is advertising for any creditors to come forward. The notices are always placed in the London Gazette, the Standard, and then it will always be placed into the local paper where the deceased lived. So you just fill out a form with the postcode and the agency will find the local paper. So although the point above says you're not going to distribute for 6 months in case any family members contest the will, you want to, as part of that 6 months, obviously the 2 months will fall into that, excuse me, where you want to be delaying distribution for any creditors. If you don't do these newspaper adverts again, you can be sued for not doing your job properly. So if you've distributed all the estate and then Santander writes you and say, did you know that Mr. Joe Bloggs had a credit card debt for £5,000? That is still payable. It's your mistake that you have distributed. We're going to come after you, the executor, for that personally. So be careful there. By placing the newspaper adverts, you are protecting yourself. All right. And I've said at the bottom there that executors can be personally sued. So there's a lot of work here. There's lots of things to do. There's lots of things to be aware of. Bear with me. So once you've got your grant of probate in, any bank account that has said along the way, this is what the value was so that you can do your HMRC tax return, but we're not going to distribute any money to you until you have got probate in. Now that you've got probate in, you can send that grant of probate to the banks. The banks probably want you to complete a bereavement form. You fill that in with where you want the funds going to. And you can collect in the money, put it all in that executor's bank account if you're doing this yourselves. And I said earlier on that you can only complete on a property once you have got probate in. So if you I have this all the time where people get too excited about marketing the property straight away and everyone's waiting for probate, it's then just stuck there. So once you've got probate in, you can release that to the conveyancing solicitors and you can complete. And obviously, once you've collected in the assets in the estate, you can then pay off the liabilities. So if there's an outstanding mortgage on a property, for example, once you've sold the property, that is then when you will pay off the liabilities. I tend to find that where there are liabilities, gas, water, electric, mortgages, loans, credit cards, etc., they are happy to wait to be paid if you keep the communication running with them. So do explain that Joe Bloggs has died, you're dealing with the probate, you will pay off the liabilities when the estate is in a position to do so and not before. You're not personally responsible for paying off these liabilities. It's all to be paid off from the estate. And if you can't collect in the estate because you're having to deal with HMRC, you're having to wait for probate, you're having to wait for a house to sell. That is then and only when you will pay off the liabilities. And once you've paid off the liabilities, you can then work out what you've got left in the pot and how that is going to be distributed between the beneficiaries. Okay, this is the last slide. I've pretty much just said what's on here, my last bit. But what you will need to do, again, I cannot stress enough that the executors or the administrators are personally responsible here. You are responsible for reporting to the beneficiaries. Okay, some people get quite sort of power trippy, thinking they're the executors. There's a lot of work to do, and it's a lot of responsibility. I wouldn't want to be a personal executor. It's all right doing it for work, but a personal one, because it's all on you. You are also personally responsible for reporting to the beneficiaries. So beneficiaries are entitled to be asking along the way, how's the application for probate going? Have you paid the tax? What's happening with the sale of the property? When am I going to receive my money? Is ultimately what they want to know. You have got the power to say we would distribute to you when all the checks in the previous slides have done. I'm still reporting to HMRC. I'm still paying off the liabilities. And until those things are done, you will wait. You have to answer them. But again, it's a bit like the creditors and the other liability companies. Once they know what's going on, that's fine. What you must do is a statement of account, is what I call it, is a statement of an Excel spreadsheet showing the beneficiaries what you have collected in. So sale of the house, Santander account, HSBC, premium bonds, total. You've then paid off funeral costs, wakes, skip hires, tring auctions, whoever, conveyancing fees, leaving a balance. And that balance is what is going to be distributed to the beneficiaries. I would get the beneficiaries to approve and sign that statement of account so that there can be no backlash on you. And certainly if they've got questions, I thought mum and dad had a, current account with £30,000 in it with HSBC. Where's that money gone? Well, if you've written to HSBC as part of your initial inquiries, you'll get a letter from HSBC with a breakdown as to what is in those accounts. I've certainly had beneficiaries ask me questions before, which means I've had to, apply for a year's worth of bank statements. They thought mum and dad had a bank account with HSBC, but we can see from the bank statements that bank was closed a number of years ago, and that fund was transferred to nationwide account. So it's the paper trail and making sure you're answering everybody. That people are entitled to ask questions. You should not be distributing to anybody until you have undertaken a bankruptcy check on anyone. There is a misconception that if you are declared bankrupt, that's all your debts wiped away, never to think about it again. That is incorrect. If the trustee in bankruptcy have written off debt for you, say £50,000, and you are due to receive a £50,000 inheritance, that £50,000 is not due to you, it's due to the trustee in bankruptcy. Again, you will be sued if you haven't done these checks and the trustee in bankruptcy find out that Peter Bloggs has inherited £50,000, but the trustee in bankruptcy have written off £50,000 by way of bankruptcy. So be careful there. If you have any beneficiaries that live abroad, you will need to instruct a genealogy company to undertake a international bankruptcy check. That will cost, and I normally deduct that cost from the beneficiary's legacy. All right, because it's not fair for those in the UK where a bankruptcy check is free. And then you've got somebody living over in France where we've had to spend £100 getting a French bankrupt genealogy company to do the check. That is to be payable from the beneficiary's legacy. Okay, so until you've got those checks come in and everyone's clear and nobody is bankrupt, only then should you distribute. I did have a case once where a chap was bankrupt. He didn't declare that to me, but I did a check on him and could see that he was. I said, I can't distribute to you because there's a debt here that the trustee in bankruptcy have written off for you. This inheritance that you're due to receive is to pay off your debt ultimately. So what he did in the end was he paid off the debt with the trustee in bankruptcy from other means. which then meant his name was then taken off the register and I could then distribute to him. But until he paid it off, I'd redone the check, his name was removed. So again, there's a lot of work here to do as executors. But provided you have got a signed statement from all beneficiaries approving the figures and how it's going to look, you've done your bankruptcy checks, you are then good to distribute. Again, I said this before, HMRC now do not really like to be bombarded with all these clearance applications, but as a belt and braces, I still do it because I don't want to be criticised by HMRC for not doing my job properly. So I still issue a clearance application. That will take a few months for them to look through, but you're personally responsible. Don't be pressurised or bullied to distribute by the beneficiaries until all the checks have been done. All right. Any general standard estate that's non-taxable, I say it could take 6 to 9 months to go through because there's all these checks that we've got to do on people. If there's foreign, overseas beneficiaries, we've got to wait for those foreign beneficiary bankruptcy checks to come back in, and that all takes time. If you've got a taxable estate, you can be looking about a year, I would say. So do be careful if you've got property when you are marketing it, because there's no rush, because it's not going to go anywhere until HMRC and the probate registry have signed off your application.